All rise. The Supreme Court is now in session. The Honorable Chief Justice Robert James will preside.
Today, you may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA24-021, People of Guam Plaintiff Appellee v. Timothy Tadautow Serebour, Defendant Appellant. Appearing for Defendant Appellant is Attorney Shannon Titano. Appearing for Plaintiff Appellee is Attorney Emily L.A. Reese. The panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Titano reserves 5 minutes.
You may proceed, Ms. Titano.
Mr. Chief Justice, may it please the court. The government had the burden of proving beyond a reasonable doubt that Mr. Serebour committed the crime of carjacking. However, the jury instructions in the carjacking case was so flawed that it wasn't clear what the government was required to prove in violation of Mr. Serebour's due process rights. And even if the instructions were not flawed, there was insufficient evidence to support a conviction.
Before we get into the instruction and then obviously talk about the sufficiency argument, I want to just look at the standard of review on of the court regarding the sufficiency argument, because there was a motion for acquittal that was made below, and so if so is it still a plain error review or is it a de novo review?
Your Honor, I submit that it's a plain error review, and that the element of violent crime was included in the jury instructions, and because there was insufficient evidence to prove that element, that was part of the reason why the jury instruction is flawed, and therefore plain error would apply in this case.
But I guess the issue is if it was preserved, I mean, to me, it's to the advantage of your client that there is a lower standard of review than the plain error. But if you're wanting to take the position that I guess even under plain error, that there was sufficient error to warrant the remedy that you're asking for. And so either way, you're saying that even if it's plain error, that you're able to show that it satisfies the elements of the plain error.
Yeah, yes, Your Honor. I'm prepared to present that argument this morning, that by including that part of the statute where there was insufficient evidence to prove that a violent crime was committed, that instruction was flawed, and that error violated Mr. Serebour's substantial rights, or yes, by not allowing the jury to determine with the correct instruction whether Serebour committed the offense of carjacking. So may I continue? Yeah. Thank you, Your Honor. So there are two primary issues, which I mentioned about the defective jury instruction, which also included the element of violent crime. And based on the record, there wasn't sufficient evidence to prove that a violent crime was committed.
So about the robbery. Well, he was convicted of third-degree robbery.
Third-degree robbery requires that he be threatened to invoke the victim to do something. But there was no threat of bodily harm, which he was acquitted of on the robbery, robbery in the second degree, which is an element to prove that. Because he was acquitted, that's another
So you're saying that the third degree robbery doesn't constitute a violent crime?
No, no, because it's just a threat. Within the carjacking statute, there are two sections, right? One, you commit the burglary and with a person in the car with an attempt to commit a violent crime or threat or cause emotional harm, which I submit is what actually occurred based on the record below, not the violent crime. I think if anything, if the government wanted to prove carjacking, it should have charged and submitted to the jury based on the record, based on the evidence presented, that it was not the violent crime, but the emotional, but causing emotional harm, which is the second part B of the statute. But if I may read the jury instructions, it says that the people must prove beyond a reasonable doubt that Timothy Tatautel Serebour, on or about March 19, 2024, in Guam did, without saying what, committing a burglary in a vehicle while a person other than a participant in the crime was actually present in such vehicle. Timothy Tatautel Serebour, another participant in the crime, committed or attempted to commit a violent crime against Vic Corla Dorion Jr., who was not a participant in the burglary and was actually present in the vehicle. And Timothy Tatautel Serebour did aid or induce John Babauta Jr. with the intent of promoting or assisting Mr. Babauta in committing the crime of theft of a motor vehicle. Now, this instruction is flawed for a variety of reasons. Your Honor, one of them is by conflating the different offenses of burglary, violent crime, and theft of a motor vehicle without clearly explaining how these distinct offenses have to show, if proven, that they were committed, that Mr. Serebour did all these offenses with the intent of carjacking and not as distinct offenses alone. As you saw, he was convicted of burglary and robbery, as Mr. Chief Justice mentioned, and was ultimately dismissed based on, I guess, a double jeopardy theory. But that and the lack of a unanimity instruction for the jury to know what the government is required to prove made the instruction confusing. There are other flaws with the instruction, which was the intent. Under Canastis, there has to be an intent to commit the offense. In the instruction, there was only an intent to commit theft of a motor vehicle, which may have been an element of carjacking, but there was no instruction that with all of these distinct offenses, that they occurred with the intent of committing carjacking. That instruction was also not included.
The government argues that while burglary and robbery may not have been defined within the carjacking statute, they were located just a couple of pages away from where the carjacking statute what the instruction was located. And so when you look at the instructions of a whole, you're able to ascertain that the violent crime underlying the carjacking charge was the robbery.
But what's not clear in the carjacking instruction is when they need to determine when that robbery occurred. I mean, even if there is a robbery instruction, and even if he was found guilty of robbery, there's nothing there showing that even if he committed robbery within the elements of carjacking, that Mr. Serebour, or even the violent crime, that Mr. Serebour committed all those acts through accomplice liability, with the intent of committing carjacking. That is an essential instruction missing within carjacking to make it confusing to the jurors. I can concede that it's possible the government met its burden, but the problem here is that it's not clear to the jurors what they were required to find in order to convict Mr. Serebour of carjacking specifically.
So in reference to the violent crime, Mr. Serebour was acquitted of second-degree robbery. And he was found guilty of third-degree robbery. So first of all, is third-degree robbery a crime of violence?
Well, that also I would submit is missing, right? It's not clear. I mean, the jurors would probably think because there's a threat of bodily injury, an imminent threat of bodily injury under a third-degree robbery, whereas a second-degree robbery is just a threat. Here, the record only provided that there was testimony from the victim that I heard gun racking and Mr. Serebour telling them to get the F out of the car, basically. And that prompted him to grab his daughter and exit the vehicle and run toward Payless. But other than that, there was no express threat of bodily
Was there
injury.
a definition of what violent crime means under the?
No, Your Honor, the jury instructions lacked a definition of violent crime. And I think that was important to have included, even if we're going to go with reviewing the instructions as a whole. That was missing from the jury instructions altogether.
So if he was acquitted of second-degree robbery and there was no definition, and was there a unanimity instruction?
No.
that was given him?
No, I'm sorry, Your Honor, for interrupting, but no, Your Honor, there wasn't. And if I may point out, he was also acquitted of possession of a firearm. So that's why I submit to this.
So where do we find under Guam law that third-degree robbery is a crime of violence?
Your Honor, I'm not aware of any statute that defines robbery as a violent crime.
So when you're arguing that because of all of this shortcomings and that the jury instructions was so confusing that it affected his substantial rights, what is the remedy that you're looking for in the event that there is a reversal on the carjacking conviction?
Your Honor, the remedy would be to remand and retry with the proper jury instructions so that it will be clear to the juries what they're required to find in order to convict Mr. Serebour of a carjacking.
Would that raise any double jeopardy issue, remanding for a retrial?
It's possible, but I think also that they can reconsider whether they're going to use violent crime as the element as an element to prove carjacking rather than causing emotional harm.
What about the other charges for burglary and third-degree robbery? The jury found him guilty of those two counts. But as you pointed out, the trial judge held it as lesser included offenses of carjacking and did not enter convictions for those two charges. Assuming that there is a reversal on the carjacking and a remand, how are those two offenses affected in reference to them, to the jury finding the Mr. Serebour guilty of those two charges? Are they affected?
No, I think they can be. I think that it's possible that the lesser included be considered. I mean, read, I don't know the exact citation and I apologize, but I believe this court has in the past, rather than remand for a new trial, actually determine with the government's consent, of course, that in this case, Mr. Serebour be convicted of a lesser included rather than retrial.
So and that would be both offenses, the burglary and the third-degree robbery?
As a lesser included, well, I think those two, well, I guess they were dismissed because it was considered lesser included of carjacking rather than armed carjacking. But it could be the two or even just theft of a motor vehicle because it wasn't clear from the record whether there was an intent to even.
So I guess the question in
Just
my
the
mind
facts.
is the shortcomings of the jury instructions, would you argue affects the clarity of the elements of carjacking and whether or not those elements were satisfied? Did the jury instructions affect the finding of guilt for burglary and third-degree robbery? Or does that mean that the two offenses, because he was found guilty, and the greater offense, assuming it's vacated, it's reversed, I'm just trying to understand what are we left with then?
Right. I think that's what's probably confusing is they could be, Mr. Serebour could have been found guilty of committing burglary and or robbery in the second degree without committing carjacking because the instructions of carjacking didn't explain that those offenses needed to be committed within carjacking with the intent of carjacking. So if they're able to prove that Mr. Serebour intended burglary as a separate offense or intended robbery as a second degree, third degree felony, then those can be upheld, if you will, and not be convicted of carjacking.
I suppose it would depend on if we determined there was sufficient evidence or not, whether there could be a retrial on the carjacking, because I think then double jeopardy might be implicated. If it's strictly an instructional error, then, you know, he potentially could and maybe even have a retrial because of the effect of that instructional error on the included offenses of burglary and third degree robbery. But and so I think it likely would depend. But how would you frame a instruction on carjacking if there was an appropriate instruction, if there was a remand for a new trial on the carjacking charge and there wasn't an acquittal for insufficient evidence?
Yes, so possibly, and of course, this probably requires discussion with the government, but maybe the instruction would read that the people must prove beyond a reasonable doubt that Mr. Serebour, on or about the date in Guam, did commit and then maybe spell out the offenses of burglary, which is enter a vehicle with intent to commit a crime, and with carjacking at that moment, right? And there was in the presence of an individual in the vehicle with an attempt to commit the violent crime, whether that's going to be robbery in the second degree. And then, of course, if there the element of intending to commit a crime, whether it's theft, but overall, with it showing that all these offenses occurred with the intent of committing carjacking, and that the jury must agree that as to which fact proved each element of the carjacking offense to lead to a conviction of carjacking.
But wasn't the carjacking charge that Mr. Serebour was being held to have violated, wasn't that as a that he was complicit with Mr. Babalta, and that was his role in the carjacking, not that he himself committed individually the carjacking crime.
Right. So my understanding of accomplice liability under the statute and canistis is that Mr. Serebour, although there is an accomplice section within carjacking, had to actually also intended the crime, the overall offense that he's being charged and ultimately convicted with, which is carjacking, and not just violent crime.
Or theft.
Excuse me, I'm sorry.
Theft, I think it was.
Theft of
Or
a
theft.
Yeah, so there was an intent, yeah, so the record didn't show whether it met the elements of theft because Mr. Babalta thought the vehicle was his. He may have not intended to take the car, but for Serebour telling him to get in the car and drive away. But when they got there, that is maybe all they had intended, was to retrieve the vehicle. But instead, he was convicted of carjacking, which the jury instructions is deficient in explaining that to charge or convict Mr. Serebour of the ultimate offense of carjacking under canistis and the statute that defines accomplice liability.
Now, getting to your sufficiency argument, it looked at the onset that is your sufficiency argument solely focused on the violent crime element, and that because when you were making your argument initially, you talked about that element being missing. But then later, it seems you were making a broader argument that the evidence was insufficient to support any conviction.
Yes, what I was trying to present to the court is that overall, the jury instruction is flawed. But even if the court determines that it's not flawed and it was correct, basically, that portion of violent crime within the instruction of carjacking, there wasn't sufficient evidence to prove that element. And if anything, he should have been charged with causing emotional trauma and not violent crime. So that's also indicative of my argument as to why the jury instruction is flawed.
So how does that affect the sufficiency of the evidence? I mean, as Chief Justice Torres pointed out, isn't that an important point in reference to the remedy that is ultimately sought, whether it's an acquittal of carjacking or a remand for a retrial? I mean, if there is insufficient evidence to support the elements of carjacking, and we agree with that. So how does that affect the disposition of the carjacking conviction in reference to a remand, any remand?
I believe that people can still prove carjacking under the right instructions without violent crime. There may be evidence to prove emotional trauma. So
the statute speaks of attempted to commit a violent crime.
Or there's another section there below that talks about emotional trauma. 9 GCA 37.310B. And that's what I'm arguing today, is that there was no.
But the overall crime is still carjacking. And if there's insufficient evidence to support that, you're saying that the government can retry on remand because of the faulty jury instructions, or a carjacking, conviction
Yes,
charge?
I believe so, Your Honor. That if one of the theories.
The insufficiency of the evidence prevent a retrial?
Well-
Because they've already had a trial to prove carjacking. We've determined the evidence is insufficient. Why wouldn't double jeopardy be implicated in a retrial?
Well, what I'm arguing is that if one of the theories included in the instruction is not valid, then the verdict, of course, cannot stand, but that reversal is required.
Yeah, but that's not based necessarily on the sufficiency of the evidence, but erroneous instruction.
Right. I'm not arguing that there was insufficient evidence to prove carjacking, because there may have been, but what I'm arguing is that the instructions were so flawed that it would warrant reversal, remand.
That's one argument. That's your
Right.
first argument. I mean, there are two issues in this case.
Yeah, I mentioned it in the alternative in case it's meant to be in reference to the jury instruction, that element, there wasn't sufficient evidence in the record to prove that element. But that's not to say that he could have been found guilty of carjacking under
Well, if
committing
they couldn't
emotional
prove the
trauma.
violent crime, he couldn't have been found guilty, right? Because yeah.
As, yes, Your Honor, as charged, correct. And if that is the case, then double jeopardy would apply. If
So
there's
that has nothing to do with the
insufficiency.
jury instructions. That has to do with the sufficiency of the evidence.
Yes, yes. I had tried to present it as a flaw in the jury instruction, but recognize that in the alternative, it could be an insufficient evidence argument.
But it's important because of the remedy
Right.
that ultimately is available to the government.
Yes. But, well, so what I'm saying to the court is if the jury instructions are deficient, then it should be remanded for a new trial. However, if the court agrees that there wasn't sufficient evidence because the element of violent crime wasn't met to convict carjacking, then I can see the standard of review should be based on insufficient evidence to prove carjacking and not plain error, as originally argued.
You have 2.5 minutes left, so.
I can just, well, let me see. So we went over the instructions and then the insufficiency of evidence. I'll go ahead and allow reserve my remaining time for any rebuttal. Thank you.
You may proceed.
Thank you.
Can you move the mic up and try and speak into it so we can capture it, please?
Thank you. Mr. Chief Justice, and may it please the court. In this case, the jury instructions were sufficient to establish the crime of carjacking. And in addition to that, it is, because this is a plain error standard, the defendant had the burden on appeal to prove that there was prejudice resulting from any error that may have occurred, and that even if that was established, it's important to remember that the decision to remand is, or reverse is not mandatory in plenary review, but is permissive.
Can we look at the jury instruction? Because you say that the jury instruction correctly defined the elements of carjacking based on the statute. And so I want to kind of look at that in a little bit of detail. So the first, the instruction 70 said Timothy Serebour did while committing a burglary in a vehicle. And then the statutory provision says a person is guilty of carjacking when he commits a crime of burglary as defined by this chapter in a vehicle. So it seems that that's there. Then the second part, while a person other than a participant in the crime was actually present in the vehicle. So that's also matches the statutory provision of 37310A. But then there's another provision that says with intent to commit a crime therein and in the course of committing the offense. And those don't seem to be in the instruction.
I would argue that they are through the sort of included accomplice liability. I think that was taken care of with the additional, I believe it's 5.
Well, it does say that Timothy aids or induces Babalta with the intent to commit the crime of theft of a motor vehicle. Where does it say that he aided or intended to induce Babalta to commit carjacking?
I don't believe that that is necessary if we're looking at other specific intent crimes, like burglary. For example, the intent is to commit a crime, trespass essentially while committing with the intent of committing a crime. And I believe that it's analogous here because.
Let's go through what we think needed to be proven for the intent provisions. You have to prove the predicate offense of burglary, right? That's for sure. And you also have to prove the predicate offense of a violent crime, right? I mean.
For this section, yes.
Yeah, for carjacking. And then there's this separate element, it's unclear what it means, but of intent to commit a crime therein. That's found in the statute. So that's an intent that's identified. And then you need the intent to support the underlying burglary, which is the theft of the motor vehicle, right? You need that intent, right?
That's correct.
And then don't you need also the intent of promoting or assisting in the commission of offense since he was an aider or abettor?
I think in this case, the statute covers that. And I do think that.
You're saying the statute alone, 37310?
Yes.
By itself? Where do you see that in the statute?
With the acting alone or with one or more persons, I think that just inherently encompasses what we would, usually include under accomplice liability or complicity.
So you think that there's not a requirement to specifically include an intent instruction of that he intended to aid or abet or promote or assist the commission of the offense, that intent is not required?
I think.
I mean, or at least be explained to the jury, they have to find that intent?
I think again, because it's a specific intent crime, you have the intent is to commit the predicate offenses. So, and I think that would be the same in an instruction for burglary. You don't have to prove that your intent was to commit burglary. It's that you intended to commit a crime in the course of doing something else. And I think for that reason, the intent required is you have the complicity part for the accomplice, but the specific intent the statute requires is to commit a burglary essentially with these other.
But here, the jury was not instructed that it needed to find that he had the specific intent of promoting or assisting in the commission of a carjacking. It was only told it needed to find that he had the intent to assist in the theft of a motor vehicle.
And I think that was included for the purpose of the accomplice liability section, because the person who actually entered the vehicle was the co-defendant Babauta. And so if you, during the jury instruction conference, the prosecutor and there's a long conversation about how that should be included, and they believe that, again, because this sort of includes this inherent accomplice liability part, and this was one or more, two people.
Like when you look at the robbery provision in the instruction, right? Or there, is it clear from that instruction that you're saying that Serebour was the accomplice or was the principal?
In robbery?
Yeah. If robbery was the predicate violent crime, which I think we agree it was the jury instructed to consider whether he was the principal or an accomplice in that?
Not in robbery, no. And I think, again, that if we're talking about robbery within the context of carjacking, I think that goes back to the language of acting alone or with one or more persons. So I don't know that you necessarily need to define who is an accomplice, because I believe it is clear from the instructions and the record that the co-defendant Babauta was the one who actually entered and drove away with the vehicle. I think that you don't need to define specifically who is the accomplice for the underlying offenses.
But doesn't the carjacking crime, as you have described it, also require that the principal had the intent to commit a crime? In this case, Babauta. Because it's an accomplice liability, it's not only the accomplice's specific intent, but also that there was the intent to commit burglary, and wasn't it the principal, Mr. Babauta, was the one that was the actor in that regard?
So yes, there would be a requirement to find that Babauta had the requisite intent. And I do believe that there was a complicity instruction specifically that should have taken care of that.
Well, the fact that Mr. Babauta was trying to determine if that was his vehicle, does that go to the sufficiency of the evidence, or the element that there was also an intent on the part of the principal that he had the intent to commit the crime?
I think that would go to the intent, and I think here is where the intent of Mr. Serebour becomes clearer, because while Babauta was still trying to figure out if it was his vehicle, that is when the intent to essentially promote Mr. Babauta into committing the theft, the lowest underlying offense. Because I believe the record shows that while Babauta was on the phone, Serebour decided that that was the point when he was just going to hurry him along to drive away with the vehicle and get the family out. So I think once that happened, that was certainly an intent to commit the burglary and the theft.
So without jury instructions specifying all the various intent requirements, how is the jury to make out and parse this all out as to what it must find in reference to finding that the crime of carjacking? As Ms. Titano points out, there just seems to be a conflating of all these various offenses without parceling out the specific intent requirements for each of the crimes that were required to be shown.
I think well, it may have been more ideal to include the definition of each underlying offense within the jury instruction for carjacking. I think the instruction for burglary and the instruction for robbery have the requisite intent for those crimes. And then similarly, during closing arguments, I think the prosecutor did a good job of explaining how this was each built upon the next.
But that wouldn't be sufficient to cure any shortcoming of the jury instruction, will it be?
It may not for the jury instruction itself, but I think, again, looking at the instructions as a whole, and the armed carjacking instruction, I believe, lays out a little bit more specifically. It does, if I recall correctly, mention that robbery was the violent crime as opposed to the carjacking statute instruction. And I think because the instructions were read to essentially consider armed carjacking and carjacking the same thing, minus the element of a firearm, I think there was certainly enough elaboration within the instructions that the jury consider all the evidence.
Well, the fact that Mr. Serebour was acquitted of armed carjacking and convicted of third-degree robbery, and there's a requirement that they must, the government has a burden of proving that he attempted to commit a violent crime. So what is the violent crime here that is alleged to have been committed?
That would be robbery.
But where does it defined anywhere or set out that third-degree robbery is a violent crime under Guam law?
I don't know. In the jury instructions, there was no definition of a violent crime. But in the indictment and in, again, the first instruction the jury would have come to, which was the armed carjacking, robbery was specifically mentioned as the violent crime. In the closing arguments, again, robbery was repeatedly used as the violent crime. And so I think even if the jury instruction is deficient, there's certainly reason to be looking at the record and the transcripts that the jury knew that robbery was what they were looking for the violent crime element.
Yeah, but if third-degree robbery, not just robbery, if third-degree robbery is not defined anywhere as a violent crime, and Mr. Serebour was acquitted of armed carjacking and second-degree robbery, how, and the jury then convicted him of carjacking with the, as you're arguing, with the thought that robbery would be sufficient to satisfy the element of violent crime. How is it that with the results that happened here, that we are assured that all 12 jurors agreed that that was the case, that the violent crime aspect was based on the third-degree robbery charge?
The only violent crime that evidence would have been presented for would have been that robbery charge. And I think, again, that was made clear through the testimony and the arguments. And I don't,
But there was no definition.
not,
And so how is the jury to glean or determine or understand that that third degree robbery charge satisfied the element of violent crime?
I think without an instruction, it would just have to come from the indictment or, you know, again, the previous instruction, which did specify, and I know it wasn't third degree robbery specifically, but it did mention robbery. And I think that, you know, they were also instructed that there was, I believe he was charged with second degree robbery and they found third degree is the lesser included. So I think they should have understood that robbery in general was the violent crime. And I think that was clear also through the
But are all robberies of all degrees violent crimes?
to my knowledge, I want to say yes, but I cannot.
I mean, what about a statutory provision, for example, that determines when parole is permitted, states that second degree robbery is a violent crime, which it does, but it does not list third degree robbery as a violent crime under that provision. Is that something we should look at? And I mean, if the jury's not clear from the instruction what constituted the violent crime, and we're just assuming, well, third degree robbery was a violent crime, therefore they should find him guilty of carjacking.
So you're asking if the
If third degree robbery was not defined as a violent crime under this separate statutory provision for determining when parole would be permitted, but second degree is, does that suggest that it's not a violent crime and shouldn't be considered as such for purposes of this carjacking statute?
I think it could be considered as evidence, certainly, as, you know, the statute should be read.
As I think there's an assumption we're making that all robbery crimes are violent. I mean, or at least I'm not making that assumption, but the people are making that assumption, it seems.
I think the use of force element is, or the threat of force. I think I would argue that, at least in this case, because there was evidence of the threat, which is, you know, what makes robbery itself a violent crime. I think that is sufficient here, as opposed, or in terms of the general statute, I don't know. I suppose it would be evidence that it could be not a violent crime.
You didn't cite any authority that third degree robbery is a violent crime, is a crime, comes under a violent crime category.
No, and off the top of my head, I'm thinking of special allegations, like, I know vulnerable victim or something, but again, that would be, because the statute doesn't define it itself, 37-310, I think you have to look elsewhere.
If this case is remanded to the trial court, would the two lesser included offenses have to be retried, or what would the government seek to have retried?
I think certainly the burglary and robbery convictions should still stand. And because I don't think those are affected whatsoever by the carjacking instruction. And I think in terms of, if we're specifically from the lesser included of carjacking, then I believe, like, I think because the confusion came, for example, the burglary was defined, and I think even though that was technically a lesser included of armed carjacking, I don't think that should be disturbed because that was elsewhere defined, and there's been no allegation that the instruction for burglary itself was, burglary to motor vehicle was deficient.
So you don't feel that the jury instructions, the carjacking jury instructions in any way tainted the burglary and third degree robbery charges or finding of guilt in this particular case?
I don't, especially with the third degree robbery that I believe, if I'm not mistaken, robbery was charged separately, so I think that should stand. And I think burglary, again, I believe was also charged separately, but it was included as a lesser included as well. So I think because there was an independent basis for the burglary instruction, I don't think that that would be compromised.
Now, the carjacking statute also has this requirement that the burglary in a vehicle has to occur while a person is actually present in that vehicle. So in this case, was someone actually present when Mr. Babalta entered the vehicle? Was there someone in the vehicle at that time?
I believe there was evidence that that the victim was sort of fleeing the vehicle, or I can't.
But the carjacking statute says actually present in such vehicle.
And I do know that there was questioning about how much of the victim was in the car, whether the door was open. So I think there's certainly evidence based on, on the record, and I think is in terms of the when Babalta entered or when Serebour decided that this whole event was going to take place and arguably formed the intent, then I think certainly there is someone within the car. And I think
But when the truck was driven away, there was no one in the truck but Babalta, right?
that is correct as far as I recall.
So isn't the point of the carjacking crime that not only do you take a vehicle, but you also take someone?
That could be one interpretation. Certainly, I think arguably the reading could be that, as happened here, you have to only enter the car, not necessarily drive away with another person actually present.
What about in reference to if we are going to reverse on the carjacking on the sufficiency of the evidence? Mr. Babalta, the evidence was such that Mr. Babalta thought that it was his vehicle, and there was no intent to steal the vehicle, and so there was insufficient evidence to prove the intent to commit a crime therein, which in this case is burglary, theft. I'm sorry. How does that affect the lesser included offenses, in particular burglary, if there was no is not sufficient. There was an insufficient evidence to prove that Mr. Babalta intended to commit the crime of theft.
I think there is sufficient evidence, but assuming that there wasn't,
Well, how do you argue that there was? What is the
I think
other evidence?
the intent of Mr. Serebour to I believe in, the co-defendant about to testify that, while he was still trying to figure out whether it was his car, Serebour decided that it was, they were going to take it. So I think that intent was not necessarily, it was not necessarily Babauta's initially. It seems that,
But doesn't that have to be the fact in order to show accomplice liability by Serebour?
I think, but it's not exactly accomplice liability. I don't believe.
But isn't that what was charged here?
It was charged just as,
No, he was an
That's correct,
accomplice. Serebour was the accomplice to Babalta, who was the one who was engaged. That was what the charge was against him. Because he wasn't the one that drove the truck. He wasn't, the one that was outside.
right, and I think oh, I see, okay, so yeah, for the theft and the burglary,
Yeah, the theft of the vehicle, the burglary, that was all Babalta, and Serebour was charged as the accomplice. There was also no failure, there was also no claim of right or mistake of fact instruction given here either, right? I mean, saying it was my vehicle as an instruction that was a legitimate defense, or I was mistaken that it was my vehicle.
not specifically that I recall.
Should that have been given as well?
I don't think so, because even if Babauta was mistaken as to the fact that it was his property or his car, and this is where I think the intent of promoting or assisting is important. Serebour still urged him to steal the truck, so I think it's.
Well, while that may have addressed the specific intent of Mr. Serebour to commit a crime therein, theft, he is, as pointed out, being convicted as an accomplice, and that you still must prove as an accomplice that the principal had a similar intent.
Right, and I think that developed, I suppose, off the top of my head, I can't say exactly when, but at some point, Serebour got out of the car they arrived in and, urged Babauta along, essentially and the family to get out of the vehicle that was stolen. And I think regardless of how the intent arose at that point, Babauta did get into the car and drive away with it without having, he thought that it might be his, but he also, when there was a family in there, I think that should be a reasonable fact that would alert you to the fact that it's not your or his boss's vehicle. And second, I think the fact that Serebour's urging he did end up getting into the truck.
All right, thank you. Any further questions? All right, thank you. You have 2 minutes, I think slightly over 2 minutes.
Thank you, Your Honor. I think, again, just want to emphasize what we stated of how flawed the jury instructions are with the specific intent to commit carjacking on the part of Serebour and I suppose Babauta, but also, the lack of definition of a violent crime and whether the separate instruction of robbery supports that. The jury instructions were just flawed. And as such, under the plain error standard of review, we submit to the court that the matter should be remanded for a new trial with proper jury instructions. I'm open to questions from the panel.
There being no further questions, the court will take the matter under advisement. We will issue a written opinion and now stand adjourned.
Thank you.